Good morning. I'm Barry Duvall. I'm president of the Virginia State Chamber of Commerce. I want to welcome the almost 500 of you that have signed up to be a part of this next 59 minutes. I know everyone's time is very valuable, and most of us are living in a new paradigm in 2020. It is the virtual world of business for most of us. We are very pleased to have you all join us, and based on the importance of this topic, we know you've come to listen and to learn and to ask questions. So I really appreciate each of you, and thank you very much for your interest. Just a couple of words about how we got here before I acknowledge and introduce our panelists. Clearly, 2020 will always be known as the year that we did not anticipate a pandemic coming to America and the impact on us economically as a nation and politically as a nation, and I think obviously from a healthcare perspective as a nation, we have yet to really fully understand. But I will say that as the president of the Virginia Chamber with over 26,000 member companies today, I am so proud of the business community of the Commonwealth of Virginia. I'm proud of how the business community has responded and the innovation of the business community. You know, when studies are done with regard to business success, what they find is companies that are always big are not always the ones that survive. Companies that are always have a long history are not the ones that survive. But the one consistent theme of businesses that do survive and do grow and prosper are those that are the most innovative and those that are quick to respond to the changing circumstances. And I would say we have had changing circumstances, and we are seeing businesses innovate and rise to the occasion. Putting the safety of our workers first is a hallmark of Virginia businesses, and we have seen that continue since the early days of this pandemic. The Virginia Chamber launched on March 6th, our first COVID-19 resource center, and we're averaging about 1,000 businesses a day attending and looking at that. We realized we needed to do more, and the way we did more was we launched a survey of over 1,000 businesses, collected their best practices to keep workers safe and customers safe, and we then put forward a plan on June 10th called Get Virginia Back to Work. And it's a blueprint for getting Virginia back to work. If you want to go to our website at Get VA Back to Work, you can see the plan that we came out with. And we did this because we didn't really see the leadership coming from those in Richmond on the best practices and the guidelines that were necessary to open safely. And so we were able to gather the best practices. We put forward that plan, and it has been reviewed and used as a guideline for businesses throughout Virginia, and many around the country and other state chambers are adopting the plan. We were pleased to see the administration step forward and look at how the administration could provide guidance to industry in Virginia. And of course, when they did so, they put forward a plan on safety and health to go into the code of the Commonwealth of Virginia. This leads to why we're here today, of course. Why we're here today is because they received over 3,000 comments, and there were a number of considerations that the board had to put forward. And on July 15th, after 4 separate meetings, these discussions concluded, and the board submitted the final emergency regulations for implementation. What do these regulations look like? What do they mean? How do they impact your business? Those are the questions that we're going to address today. And again, I'm mindful of your time, and I promise you we will adjourn by 11 a.m. Let me quickly tell you the agenda. I'm going to introduce Courtney Malveaux and Rob Bohannon, 2 longtime Virginia champions of business and industry. And then they're going to each make a presentation. And then I'm going to transition to Q&A. Some people have already submitted questions that I'm prepared to ask them each. And then after each of them speak for about 15 minutes, we'll have time for Q&A, and we'll wrap up about 5 minutes to 11. I know former commissioner has to get off, Courtney Malveaux. So let me move towards those introductions. Thank both you gentlemen for being here. This is a Zoom webinar. We capped out at 500. We have 500 on the line right now, and each of us are in our respective remote locations. But Rob, I want to compliment you on being the best dressed business person I've been with in the last several months. I don't know if I'm going to even know how to tie a tie after the last 2 months. So thank you for.
I need the practice.
Let me introduce Courtney first, and then Rob. Many of you know Courtney Melvo. I had the opportunity to work with him when I was in state government as Secretary of Commerce, and he was in the private practice. Courtney obviously has a long and distinguished career. He is a principal of the law firm of Jackson Lewis, and he helps lead their workplace and safety and health practices as well. He has a number of other specialties, including helping construction industry groups and the like. He's an expert on OSHA, and he's had several high-level appointments in public service that indicate that. As I mentioned, he served as the Commissioner of Labor and Industry. He also served on the President's National Association of Government and Labor Officials, and he has chaired that group as well. Courtney also recently and has been appointed to the Virginia Safety and Health Codes Commission. We're pleased that he is on that commission. So I'm going to welcome Courtney, but I'm going to go ahead and introduce you to Rob, so you can flow right in after Courtney's presentation as well. Rob has been a longtime advocate for his clients and business. He is the Director of Government Affairs for Hunton, Andrews and Kurth. I still have to remember to say that name that way. It's a great name, great company. And it's obviously a well-known firm with great partners in that firm as well. He works in legislative and regulatory affairs across a number of different industries. Lots of experience in working with the governor's offices and state attorney general's offices, as well as securing support for amicus briefs and the like. So these two gentlemen are both well qualified to be with us today, and I look forward to Courtney, your sort of technical overview and expertise, and Rob, your sort of review of how businesses are responding. And just I'll ask you to go first. I'd ask for a round of applause, Courtney, but you wouldn't hear it. But I think you have some PowerPoint slides that my team is putting up for you. So let me turn it over to you for the next 10 or 15 minutes, and then Rob, I'll quickly segue to you. Thank you and welcome, Courtney.
Absolutely, Barry. Thank you for your time, and thank you all for participating. And so there's a lot to it, and I'll try to get through what I can in a fairly brief time, at least in terms of what's most important. And so if we could advance the slide, please. So what I'd like to do, as I mentioned, I stepped out from serving as our labor commissioner, so I went from overseeing and enforcing OSHA for the state to now representing employers. And so I really wanted to try to take what my understanding from the agency was and share it with the business community, because frankly, if the business community is not part of the process, then all of it falls apart. And so there's a lot to it. I wish that the standard that was passed was a little bit more clear. Sometimes it's a little contradictory, and I will tell you, I put in a significant amount of work with the agency to amend it fairly significantly in some ways that would make it more clear for the business community what the agency was requiring of it, and also to sunset it. I thought it was important that it not outlive the governor's emergency orders, and so we attached a sunset to it. If the emergency orders expire, so does the standard. Going forward, actually go ahead and advance this. I'll tell you what I'll do is I'll just talk about a brief background in terms of the emergency standard, then I'll talk about what's in it that applies to all employers, and then to more medium and higher hazard employers. So here's the background. Let's advance the slide, please. So following, many of you have been aware of the governor's emergency orders in dealing with COVID. If you could advance the slide for me. And so in response to that, the Virginia Department of Labor and Industry, and within the Department of Labor and Industry, there's Virginia Occupational Safety and Health, or VOSH. Consider that OSHA for Virginia. And so VOSH enforces the occupational safety and health laws, our state version of it. And so, and it covers most of you who are on this. It covers just about everybody with exception of any federal employers, anyone working in federal property, and the maritime industry. Could you advance the slide for me? So in response to the governor's executive orders dealing with COVID, there is the VOSH has implemented an emergency temporary standard, and it was passed by a citizen board of individuals. I'm one of the attorneys on the board, and there are those who represent labor, those who represent industry, and a couple of agencies that are relevant. And so we passed the OSHA regulations for Virginia. And so there's a wide variety of opinion in terms of what should be done or whether something should be done. In disclosure, of course, I'm kind of a business guy, so I took a rather skeptical view of having a new and additional standard of OSHA's authority that it had. But my point was actually one that was in the minority, but it worked to make it something as helpful as I could for the business community. So ultimately, the board did pass a first in the nation emergency standard for COVID-19, and that just happened on July 15th. There will be other states that run their own OSHA programs like we do, and I think there are some, especially some states in the western part of the country. So you'll see some other dominoes fall where if you have operations in, say, California, Oregon, Washington, New Mexico, Minnesota, you're going to see that there will be other states that will follow suit after Virginia. I've been kind of asking whether, given the last General Assembly session, and I don't know, Barry might have thoughts on this, whether Virginia kind of became the new California. I think in this case, we've actually left California in our dust, and California is actually playing catch up with Virginia in terms of passing a COVID standard. So anyway, I'll leave the editorializing to the side now and stick to the law. So the emergency standard has a 6-month duration, which means that the effective date was yesterday. Take a breath. I just spoke with the head of safety in the agency, and there's a lot of confusion within the agency in terms of what the standard means. A lot of the provisions are not entirely clear, despite my efforts and others. There are provisions that are contradictory or undefined. And so if you're a little confused, it means you're getting it. And so the agency is not enforcing it and cannot do so without training, which is something that it is not done. So take a breath and understand that the things I'm talking about, while they have been given an effective date of yesterday, that the agency is still putting things together to try to get up to speed in terms of its enforcement. As I mentioned, it'll sunset upon the expiration of the governor's state of emergency. And the only other thing that there is a possibility, and in my view, a probability, that assuming the governor's emergency order remains in place through the end of the year, that a permanent standard would be considered. At that point, and I would say start to pay attention around October or so, and there will be opportunities for public input and input from the business community and stakeholders, which I think will make a much, much better product than what we have now with the temporary standard. Could we advance the slide, please? So I'll talk a little quick about the requirements for all employers under VOSH jurisdiction. Could we advance? When I say VOSH jurisdiction, I mean the all state and local employees and all employees of private entities, with the exception of perhaps federal contractors or working on federal property and maritime industry. So the structure of the standard breaks down employers into very high, medium, and low hazard places of employment. There's a lot of confusion over whether that applies to industries, job tasks, or to work sites. And so there was a lot of debate about that, and unfortunately the standard applies these terms to all three. So I try to emphasize to employers do as the agency, I think, will do, which is to keep safety as the watchword. The important part is if we keep some sense of working towards safety and what works in workplaces to achieve that, then I think as long as we keep our eyes on that longer goal, a lot of these smaller things will work themselves out in this very, very messy process that we're in right now. I can't mince my words on it. It is a very messy process, but I think also that I emphasize to folks, personnel is policy. Who's in charge has a lot to do with how the policies are implemented. And so if we know who we're working with in the agency, and if we know what their priorities are, and we're keeping an eye on how we accomplish those, that will go a long way in helping us negotiate this minefield of this very complicated and self-contradictory standard. I can't mince my words. That's that's honestly how a lot of folks are seeing it. So it includes some requirements for employers. It's going to require some policies and procedures to report to employees to report COVID symptoms to their employers. And one thing that is causing a lot of confusion is an undefined term. It's flexible sick leave policies. We're all familiar with the Family and Medical Leave Act. We're familiar with the Families First Coronavirus Response Act and what those provisions require. What flexible sick leave policies are required by this standard, we don't know. I do question, and I do question whether it's VOSH's jurisdiction to require flexible sick leave policies, but so we'll see to what extent the agency cares to try to flex its muscle on that. So the employers will have to develop systems to receive reports for positive tests from employees and also subcontractors. The Occupational Safety and Health Act and our corollary in Virginia law address safety among employees. And so COVID is, of course, a hazard that can be shared not just between employees, but also visitors who come onto a work site and share it with your employees. It could be subcontractors who are not your employees on your work site. So it could be introduced through those, through other avenues. One interesting thing in Virginia that it does not exist anywhere else in the union, as far as I'm aware, is a requirement both for hand washing stations and hand sanitizer. Now, right now, that's probably not much of a burden for many employers because it seems to be more readily available. If there's another run on hand sanitizer, then I did work with the agency to add the language where feasible. Feasible, it will be if we run into that situation, feasibility will be defined by the agency, not by employers. Fundamentally, I did share that I had an issue with this, but it's what the board passed. And so that's there, and that's something to be mindful of in case we have a situation where there's a shortage. So the employers will have to assess the risk levels of the employers and suppliers who come on their site. How that will be done, we don't know. For some employers, I spoke with one that has upwards of 50 suppliers coming to its site every day, and they have no idea what localities are passing through. It could also have implications for interstate commerce, but it's what's in the standard now. And I think if we move toward a permanent standard, that the input of many of you will make this a much, much better standard if and when that occurs. So, and finally, if there are any owners of buildings or facilities, and that includes non-employer owners, they actually have a duty under VOSH to report to tenants who are employers of known COVID cases. And that is, at this point, interpreted as facility-wide. Can we advance to the next slide, please? So, the employers, this is new. So employers will have an affirmative duty to notify the Virginia Department of Health of positive COVID tests. In addition, there's what I personally call the hotspot rule, which is if there are 3 or more positive tests that within a 2-week period, then they would have to report to the Virginia Department of Labor and Industry, or VOSH. Now, the language is a little ambiguous in terms of whether the 3 or more standard would apply by workplace, work site, or by employer. And there are many who have work sites across the state or multiple work sites. So the agency, as far as I can tell, is not sure what is meant by that in the standard. And so I would think that a more reasonable rule would be one of 3 or more at a work site. And I do hope the agency takes that approach. It makes more sense to me. And so there are hazard assessments for job tasks that will have to be completed. And so I did talk with head lawyer who was involved in the drafting of the standard. And while it's not necessarily in the plain language, I developed an understanding that the agency doesn't intend for you to create a spreadsheet of every single job task at your work site, but rather to try to group your job tasks into categories so that if you have people who are working in an office setting, that they may be considered low hazard, but if you have someone, say, on a manufacturing floor, that they may be considered medium, et cetera. So, and also there's a requirement for employers generally to put together an infectious disease preparedness and response plan, and that's within 60 days of Monday. So you have a couple months to do that. Can we advance the slide, please? Unfortunately, I have more general requirements for everyone to share. It doesn't end here. So there is, I think the language in, if you bury into a section 10G, there was initial language by the administration saying essentially this: we've all been complying with the CDC guidance. We've all been looking at the OSHA guidance. And if you've been following that, then you've been in compliance with the standard. There are some who weighed in and they reduced that safe harbor into something that I think is not terribly effective. And so generally, while you have those who have been following CDC guidance are in a good place, that won't constitute compliance with the standard, but be considered good faith. And I think good faith in the VOSH context, if you follow its field operations manual, its internal processes, that may mean good faith in terms of penalty calculations, rather than not being in a violation of the standard. So all that is to say, I think that 10G safe harbor that many of us were hoping to have for business, I don't think it has the effect that we were hoping for. I think we have to look at the standard and really kind of get into the details and try to follow it as it's written as well as we can. Then additionally, there non-discrimination, that's anti-retaliation provisions. We all have them in our internal policies. And so employers cannot discriminate or retaliate against employees who voluntarily use personal protective equipment beyond anything that's required or needed for the work site. If you have an employee that says, I have an N95 mask and I want to wear a doggone it, then you can't require the employee not to or take action. Employees may report concerns. I try not to editorialize too much, but in my view, I can't mince it. I think it's unfortunate that it includes protection for employees reporting on social media. So if an employee goes and says on Facebook, my employer does this, that, and the other, and it's a big, huge hazard, excuse me, whether it's true or not, it is a protected activity under this standard. And there's also anti-retaliation for employees who make a reasonable refusal to work. And so that's, long story short, employees can't just walk off the site en masse. They can't, they have to have a reasonable, objectively reasonable fear that in their particular situation that they have an immediate hazard of getting COVID, and they have to really interact with the employer to give you a chance to resolve the hazard. So this is not everybody can just walk off the job site and expect to get paid for nothing for weeks on end. That's not what this is for. Could you advance the slide for me, please? So I add in the requirements for low hazard employers because they tend to apply to everyone. And so the low hazard requirements apply up the chain to middle and higher. So low hazard employers are considered those in which there's no required contact within 6 feet of known or suspected COVID cases. I saw already that there was a question in terms of what does this minimal 6-foot contact mean? The CDC has a rule of thumb, and it's called the 6-15-48 rule. If you're within 6 feet of someone for upwards of 15 minutes within the last 48 hours, then you should take additional protective measures. You may have of someone who has a positive COVID test or shows the symptoms. So that 6-15-48 standard is not in a rule, is not in this standard, but I think that's a very reasonable way to apply the standard. So I would continue to use that as a rule of thumb unless and until the agency decides it would do something other than that. So it's designed to be like the office setting where you have minimal contact with other people, separate offices or cubicles, or you're kind of spaced out, that type of thing. Incidental contact as you pass people in the hallway or in a restroom or in an elevator, that's probably not going to qualify. So, and these types of things can be resolved, and the standard specifically says that you can resolve them through controls such as floor to ceiling barriers, telecommuting to teleworking, really, I think is more the term they meant. Separating people by time or space in different parts of the workplace or by different shifts, mandating social distancing and face coverings. Can we advance the slide, please? So I'll talk about medium hazard employers, which I think many of you are going to fall under. Could you advance, please? Okay, so the medium hazard are those in which there isn't minimal contact within 6 feet of others. And so again, maybe, I know you're not out there with your stopwatch figuring out who's inside of someone at 6 feet for 15 minutes or more, but just using some sense and doing your diligence, you should be fine. So the agency lists a number of industries that it would deem medium hazard. And again, in other places, it talks about tasks that are medium hazard. And of course, within any one of these industries, you can have people in low hazard, medium hazard, high, depending on what they do during the day. So these, I just list some industries that would be considered medium. Agriculture, poultry, seafood, and meat processing initially were considered high, and that got lowered to medium. I think that was a good move because of protective measures they've taken in the last few months. You know, the restaurants, the bars, grocery stores. Could you advance, please? So people involved in manual labor, your manufacturing settings, construction, both indoor and outdoor, retail stores. Could you advance, please? You'll have a copy of this, by the way, after this, so you can have this as a resource. And so there are requirements for medium hazard employers. And so the agency says when feasible, and feasibility, again, is in the eye of the agency. And so we're going to make this work as well as we can, and hopefully without too much legal wrangling, but I think unfortunately there will be some legal wrangling over the terms. It's just part of the process. So this, instead of suggesting, now the agency is saying thou shalt, when feasible, allow workers to telework and use staggered shifts, physical barriers, eliminating travel or personal meetings when you can, and remote delivery of products or delivery or pickup, and reconfiguring spaces. And when you reconfigure spaces where people congregate, that means like your break room. You go back and you look, okay, if we were to distance people out, how would we mark that off? Maybe tape on the floor. Some people are using hula hoops to tell people if you stand in this hula hoop and someone else is in the other, that you're probably distance apart, whatever works. And then also post things in terms of what is the capacity of the room if you distance appropriately. Could we advance, please? So everyone will have to do an infectious disease preparedness and response plan, with the exception of employers with 10 or fewer employees. And so it has various requirements in the plan. And to answer another question that I saw in the chat room, there, if you go to the website, and I can share that with you, There is a link to checklists. There's a PowerPoint. Their PowerPoints are not the most exciting, although I'm one to talk. And there are resources there that help you to put together this plan and the required training. And so it does have an employee involvement component, and that's a great best practice anyway, which is when you're identifying hazards and solutions, involving your employees to tell you what you don't see is always a great idea. So I really emphasize that. And by the way, as you go through and do your diligence, document. The more you document your diligence you're doing on this, better life gets if, God forbid, OSHA shows up for an inspection. Then we can pull out the diligence you've done and show, oh yeah, well, this person may have been complaining on Facebook about all kinds of things. This is what we're really doing. We're addressing the real hazards in a way that you contemplated in the standard. And that'll make life a lot easier if we're dealing with the OSHA inspection. So you have to consider employees who may have other jobs with other places of employment and bring there, if someone has a higher hazard, brings it to your place of work. How do you deal with that? The agency does, I think, exceed its authority in a number of ways in the standard, one of which is requiring employers to consider their absenteeism policies or how they'll deal with interrupted supply chains or delayed deliveries, or how they'll continue to operate. I think those are business decisions that the agency did not need to step into, but it is included in the standard. Can we advance, please? So there's pre-screening or surveying before work shifts. That does not necessarily mean temperature taking, but it could mean just asking people, advise us if you have various symptoms and follow the CDC symptoms, you should be good. So they're there to provide face coverings and contemplate hazards brought in by visitors or others. Could be an infection prevention, and so I've mentioned that before. Could we advance, please? So getting to the end, so there should be written certification to verify that you've assessed the workplace hazards. And finally, there are some requirements for air handling systems. And so you have to ensure that whoever's in charge, the owner or the employer, whoever has control over the air handling system, that it is compliant with manufacturer's instructions and meets certain requirements. Could we advance, please? I think we did miss, oh, okay, here we go, the training. Just be aware that within 30 days of yesterday, there will be required training on the CDC guidelines, on your infectious disease preparedness and response plan, on risk factors, personal protective equipment, and safe work practices. Could we advance, please? So I'll just offer this as a resource, the requirements for very high and high hazard employers. Could we advance, please? And so, and I think this does not apply to most of you, so I'll leave this as a resource, but there are certain requirements for mortuaries, for those who are the true frontline workers in healthcare, those who, there's psychological and behavioral support for people because they often deal with the trauma or the stress of handling individuals who likely either do or likely have COVID. Could we advance, please? So I think that's it, and I'll end, and Rob, if you'd like to go. Any questions? Glad to answer.
I think we're going to hold questions, Courtney. Great technical presentation. Rob, we're going to bring your PowerPoint up and ask you to jump in, and I know you have about 10 minutes or so as well, and we appreciate that, and then we'll do some Q&A. Rob?
Gotcha. Well, thank you, Barry, and thanks for having me here. What I would like to do is kind of, if you could advance to the next slide, is touch on briefly the labor-related issues that we came out of the 2020 General Assembly session, how this is really a continuation of some of those efforts. And then really the COVID-19 pandemic really accelerated some of the regulatory action that you saw in these regulations. Touch briefly on some of the messaging from the governor's office, because I think it's important to understand where they were coming from in some of this, and some of the feedback and the messaging that's been on some of these regulations since they've been put into place. And then finally, just really touch on what's really important is what challenges lie ahead. Next slide, please. So if you were around or a part of the General Assembly session this past year, you saw a whole bevy of labor-related bills filed that for the first time really in many years had any chance of passing with a Democratic takeover of both chambers. Minimum wage legislation, paid sick leave, worker misclassification, right to work repeal, fair share legislation, which really would have undermined the whole right to work law. All those were on the table this year. And in many instances, they made a lot of progress for proponents. One key piece that was left undone by proponents of greater workplace regulation, leave bill. Bill died on the last day of session because they felt it went too far. ACA had allowed, and that was a real sticking point for a lot of very pro-worker, pro-labor proponents in the General Assembly. And what we heard time and time again, we heard it during the session, we heard it during the development of these regs, is that the talking point that Virginia might be #1 for business, but it's 51st for workers. And that came from an Oxfam study that was critical of Virginia's minimum wage and critical of labor protections. And that sort of messaging went through the session and then tumbled over into the development of these regulations. Things like worker misclassification, unfortunately, there are proponents out there that felt that this is the way business gets done in Virginia. We heard that time and time again, that really did not take into account anything good that the employers and that the businesses of this Commonwealth are doing to protect workers, to provide safe environments. And it's really, has drifted over into this space now that the legislative session has ended. Next slide, please. Can we advance the slide? I'm sorry, go back one, please. My mistake. What we saw in April is advocacy groups representing poultry and meatpacking workers petitioned the governor for greater workplace safety regulation, and they provided a template for those regulations. And really, a lot of them were even more burdensome on business than what you saw come out of this regulatory process. I'll just give an example. There was one provision in there that basically said, the regulations allow a worker to not enter a work site that they feel is unsafe. The proposed regulations initially said you don't have to enter a work site that's unsafe, don't have to do any job task you think is unsafe, and the employer then has to find you a more suitable job that you do think is safe and has to pay you during that whole process. So there were some very, very burdensome regulations that were proposed initially. What is really interesting during this is that the business community didn't really have any input. I mean, these regulations were published. I think business had maybe 3 or 4 days to provide written comment, and then that was it. There's no public testimony, no other opportunity to provide input. And these regs, in each subsequent meeting, there were changes. There were amendments offered. The governor's office offered amendments. There were amendments offered by board members on the fly. And really, there was no sort of input by those who would be charged with implementing those regs. Next slide, please. What we heard time and time again from the governor's office was that Washington wasn't doing regs or CDC guidance, but it wasn't enforceable. It didn't provide a real tangible standard for employees, and that Virginia needed to lead the nation in this effort. We heard Dr. Healy, Dr. Healy is Governor Northam's chief workforce advisor, talked about the thousands of complaints that had been received by workers who were and the thought was that Virginia would then lead the nation in this effort. What is interesting, I think, one thing that occurred during this reg development process is Dr. Oliver, who's the Virginia Department of Health Commissioner, joined one of the calls and talked about how what the poultry industry had been doing to protect workers. And keep in mind, they were the original impetus for the need for regulation. And since some initial outbreaks and challenges, they've actually received very high marks from the Department of Health for the work that they have done to implement safety standards for employees, to protect employees. And Dr. Oliver's comment was, others acted in the same way. And keep in mind, the poultry and meatpacking industry did this without any regulations in place. They did it because it was the right thing to do, and they did it because acting. Next slide, please. One of the big broad concerns that was there was little input from those who were having to implement these standards and having to, again, most of them are already following CDC guidance and recommendations, and now you've got another standard on top of that you need to work with. And there really was, during all the press coverage of this and some of the messaging out of the governor's office, we never heard anything about the good work employers are doing. I know, the times I've been out to wherever I've been in public, I mean, businesses are doing so much, going over the top to protect employees and to protect the public when they're in those places. And I think, most entities are doing an incredibly good job under very challenging circumstances. And then again, we heard a lot of assumption that was talking about when you get COVID at work. There was no assumption that, the workplace represents a small portion of a worker's day. You leave the workplace, you go on vacation, you go to the beach, you go to dinner, you go wherever. There was no assumption that there could be other places where an employee could get COVID, and it was so focused on the workplace, which I think was a big challenge as well. And lastly, I'll just touch on briefly before we can get to some Q&A, which is probably what a lot of folks want to get to on the next slide, is some of the key takeaways for business that I think folks need to be paying attention to. The big thing that Courtney touched on is that the CDC compliance may not be enough. Obviously, some of that is changing, I think. We're getting new information every day. A lot of businesses are using that to rely on how they operate their workplace, but the language in the regulations that was changed, I think, 2 or 3 different times in the development was, it's got to be equivalent to or greater than what Virginia's workplace regs are, and that's something that employers are going to have to figure out. The other thing Courtney touched on too was, the idea that an employee can now go on print or social media, ding what a employer is doing with regards to protecting employees from COVID, and there's little recourse now that the employer has in that regard. The other thing we're seeing out there now, and if you've been watching the news at all and some of the stories in the paper, there's a lot of conflicting information coming out about the executive orders already about, we've heard this from several clients that we've gotten a call that we have to enforce these mask mandates. Well, that was said originally you didn't have to enforce them, and it wasn't on the employer. Another layer of regulation in here, I think, is going to cause challenges for employees or employers when it comes to how they differentiate between all these different requirements that are out there. And I think the big thing that, me as a lobbyist keeps me up is expect more legislative action. We've got a special session coming up here on August 18th. I think you'll see some efforts to possibly codify some of this. And then going into 2021, again, I think there was a lot of, by proponents of greater worker protections, there was a lot of unfinished business, and this pandemic will help propel some of that activity and see a greater need for a lot of folks to implement greater worker protections through the legislative process, which obviously is more permanent. Barry, with that, I'll turn it back over to you.
Both of you have done a fantastic job, and my team is telling me that we will have this video and your presentations available to everybody. So that's a question that's been coming in. We have probably about 12 to 13 minutes left, about 10 minutes of your time. Courtney, I know you have to jump off at 5 till. Let me just jump into the questions that have been submitted in advance, and we'll try to get to some that have been submitted already. One question is just a practical question. I'm going to send this to you, Courtney. Do evaluations and risk levels need to be done by an outside entity? Can companies do their own evaluation? Is there any guidelines on this place that people can go to learn and be helped in this area?
It can be done internally, it can be done externally. So there is a link on the agency's website I can share that provides some materials and checklists that will be helpful. And so the agency does also offer and is reaching out with its consultation program, which is very attuned to this new standard, and will actually go and share with you their compliance with the standard without enforcement being involved, assuming that you abate any serious hazards.
Thank you. And next question, Rob, I'm going to send to you. I know you alluded to this. It's a two-part question. The first is I'm going to quote the former Commissioner Malveaux. I think he said we may be moving towards California or passing California. I guess my question to you is this. What do you anticipate coming up in either the special session, or should we be preparing more for these issues in the general session? So I know there are a lot of people on the call that are interested in all these factors, so I'm going to put you a little bit on the spot. What do you think the special session is really going to be about, which may or may not be this topic? If you think it is, we want to hear that special session, and then pivot to you think we should see this in January.
Yeah, and that's a great question. I think it's on everybody's minds these days. I think special have really yet to be clearly defined. Obviously, the budget is the big piece. We froze all the new spending, and there's looking at the reforecast of the budget and how that kind of where are we and how much money maybe is coming from the feds. There obviously is an issue. And then you've got the police reform and social justice initiatives that Speaker Philicorn has already said are going to be a part of the special session. We have not heard and gotten any clarity specifically yet on how much more. I think there is a desire to keep by many in leadership to keep the special session somewhat limited. But when you open up the budget, that becomes a very challenging process as well. I think 2021 certainly, and all the issues that we dealt with as a business community in 2020, the stuff that what we were successful on, the right to work, the fair share, that kind of stuff is going to be right back front and center. Paid sick leave is one I could see going to a special session or a regular session, just because it does affect the COVID pandemic, and that was really a really bitter defeat for a lot of folks. So I think it's going to be both, but 2021, and keep in mind 2021 is an election year too, so it's going to be very chock full of stuff.
For those of us who are on the call that are advocates for clients or our businesses, I would say to you that your clients and your members need you more now than ever. There's a real awareness growing in the business community that what Courtney said earlier, and he said personnel equals policy. I will tell you, politics and elections drive those personnel individuals, both elected and appointed. And believe me, appointed can be more impactful than elected in America today. So we need to be engaged. We are engaged. And Courtney, I guess I'd like to ask you to think about the makeup of Virginia business. And hopefully you can speak to this as a commissioner and speak to this as maybe those who are in office today. We know there are about 270,000 operating entities in Virginia at business at some level. We know the majority of those, over 90%, are small business with less than 250 employees defined by Virginia. But we know that there are really a significant number that are truly small businesses, less than 10 employees, less than 50 employees. What do you say to them? What do you anticipate DOLI's disposition to them? Specifically, will there be flexibility for small businesses? Do you see any carve out or exceptions for small businesses in these regulations? And what do you anticipate small businesses' future is under this environment?
And thank you for that. And there was that exception for 10 or fewer employees in terms of the plan. And so that is a good thing. The other requirements, not so much, but the agency does, well, it's not much of a consolation, but they do give penalty reductions depending on size of business. I do think this is, I can't mince it, I do think it's unnecessary, the standard. And I do think that it places a lot of burden, especially on smaller businesses and those with fewer resources. But I think the agency does have people who want to reach out to small business and are doing that. And I'm trying to reach out to employers of all sizes as well to try to be a good resource for all of you. So, but if you're following the CDC guidelines, a lot of this is already in place.
Thank you. And we'll have your contact information and Rob's contact information available for everybody as well. Rob, I'd love to ask you about a matter that's been talked about nationally politically. We'd love to see it in Virginia if we can, as business advocates, get it. It's referred to as the safe harbor rule. I'm sure you're familiar with it. Maybe you could define what that means when people talk about it in the legislation being contemplated now. You could read about it online, but why don't you define safe harbor rule and a little bit about the legislative discussion around it in Washington, and if you think it's even possible in Virginia.
Well, and I'll fully admit I'm not as I assume you mean the protections for, sort of basic protections for businesses that
liability
are out there.
Protect, right.
Yeah, and I know a number of states, I think Utah did something. I know North Carolina did, and I've been in close contact with a colleague in North Carolina, and basically, essentially if you're doing everything, you're posting the signage, when people come into your business, you're putting basic parameters in place, absent, really negligent conduct, you would be protected if, someone came after you with a COVID claim, essentially. And I know in North Carolina, particularly, what really, so one of the challenges, could something like that pass here in Virginia? Because it may seem like a no-brainer, but Tennessee tried to pass one. It did not. And in North Carolina, talking to my colleague there, who were more on the far, what really got them involved was higher ed. Your Dukes, your UNCs, your UNC Asheville's, they got really involved and said, we need this, and that really, I think, turned the tide there and got most folks on board. So I know folks are really hopeful it's something at the federal level, but it's something that a number of states are looking at here. But I think, it would not be a slam dunk by any means here in Virginia.
Rob, we want to build on that. For those of you who are on the call connected to higher education, I really want you to be in touch with us and Rob's firm and Courtney's, because I think there is a real need to look at our institutions of higher education, both public and private, and bring them into this discussion. While they aren't necessarily viewed as a business entity, they have huge economic contributions to the Commonwealth. They impact us in a number of ways from a workforce and education perspective, and they have great liability, and they are just as interested. They may not be able to go as public as we can as advocates, but we need to be in touch with them and represent their views. So great answer, Rob. Thank you for that. I know I'm going to lose Courtney here in just about 4 minutes. So I wanted to pivot to some technical questions that have come in, and you can answer these as fast or as quickly as you can. Are there any guidelines, and is it as specific as to having to keep records on a daily basis? And if so, what are the records? Do they have to keep temperature records by employee? How burdensome is this? How descriptive is it at this point, Courtney?
There's no requirement to keep temperature records, and I will tell you, if you do take on the burden of maintaining them and also protecting them as medical information. So, and also there are data breaches out there. So there are some serious possibilities which may not be good if you're keeping temperature records.
That's great. And Courtney, I know you need to leave in a couple of minutes, so I'm going to ask you this final question, or this final comment question. And you don't have to be the technical advisor only now. Just sort of reflect on, and I'll be coming to Rob in just a minute for the same, just sort of reflect on what we've been through in this process and reflect on the status of these regulations. What are your sort of recommendations for people who are listening on the call, recognizing they may be leaders of associations, recognizing they may be government affairs people within a company? There are also HR directors, human resource people on this call with our Society of Human Resource Manager partnership. What are some of your final thoughts about how these companies should respond to what's being put forward and where we are in the process?
So Barry, when I joined the Safety and Health Codes Board, I thought I was signing on for the most unexciting aspect of my life imaginable. It's just reviewing OSHA regs. That should not be exciting. And then suddenly it's ground zero for everything. You have to pay attention, you have to be involved. Nominate people for my board. I can't be the only one to speak for business because I was begging for logical reasons for these policies. I wasn't getting them. That's a problem. And so be involved and make yourself your voice heard. And I wouldn't take no for an answer. If the administration tells the business community thou shalt not speak, no, because when I was labor commissioner, I had too many workplaces for my 60 or 70 enforcement officials. Workplace safety can't get done without the people on this call. And if you shut them out of the process, you're precluding safety. So I ask folks, get involved.
Get involved is the answer. If people on this call have an interest in being on your board, Courtney, I first of all would like to invite them to email me at the Virginia Chamber or bduval@vachamber.com and tell us that. Do you have a recommendation from another perspective? I mean, we do make recommendations. We're not always successful in getting them on there. Is there another stream to get people on a board like that? And we'd love to make that available to people.
Sure, absolutely. It's on the Secretary of the Commonwealth's website, and get yourself nominated, and also get a few recommendations from people who might kind of catch the attention of the governor or others in the administration as someone who has something to add to the board. And hopefully varying perspectives will be valued as helping to create a better product.
Courtney, thank you for joining us. I'm going to focus on Rob for the last couple of minutes and give him a chance. Thank you so much for being here. I know you're available to help your clients, and we appreciate your PowerPoint and presentation. Great job.
Thank you. Okay.
Rob, sort of the same question for you as I close. Based on the process that's taken place in 2020 and all of your experience as it relates to government affairs, what's your recommendation to those people on the call? What do you think they need to be looking for? And what are your final comments as we move towards closing?
Yeah, and first and foremost, and I hate to do this now that he's off the call, but Courtney does deserve a round of applause from everyone on this call, because his back's probably sore from carrying a lot of the weight of trying to, put some parameters around some of these regulations that came out. But I think the biggest thing is, while these regulations are, challenging and burdensome, let's think about the bigger picture here. Have these conversations with your elected officials, because I think there's going to be an effort to codify some of this. And when I'm in a legislative hearing in 2020 and I hear, well, worker misclassification is just how contractors do business. I mean, that I take great offense to that on behalf of my clients, because I know that the construction clients I represent surely don't do business that way. But there is oftentimes a perception out there, and I think businesses need to hold elected officials accountable when they say things like that, or that you're not treating your employees fairly because you're paying a certain wage. They're not looking at the other opportunities you're providing. And your elected officials need to hear what you are doing to protect employees, to keep businesses going, because let's be honest. I mean, if we can't keep some of these businesses going, the recovery is going to be 10 times more challenging. And I think that gets lost. I was consistently bothered by the fact that we never heard the good news coming out of what businesses were doing in all of this. And it was all bad. And that's, all people on this call, myself included, we've got to change that rhetoric.
Yeah. Well said. Thank you so much, Rob, for participating today. I also send my thanks again to Courtney. Thanks to our communications team and policy team for putting this together. And thank you all for participating. We'll make this available to you, and look forward to working with you to create a brighter future for Virginia. Let's keep advocating for business-friendly policies, because businesses do lead, they do care, and they do help create the wealth of our Commonwealth and our country. Have a great rest of your week. Bye-bye.
Thank you.